it certainly seems that if the federal government, let's say that they were enacting a raid because they felt that there was an individual who couldn't possess firearms and somehow got one, they're trying to raid, that person could have picked up the phone and said, hey, local Missouri sheriff,
Yeah.
get over here and basically fight with
Yep.
the federal government about protecting me.
We are the Arms Attorneys. Today we are talking about the latest update in the federal government's attempt to take down a Second Amendment Sanctuary Act. We're going to talk about which state's act maybe finally bit the dust here, why this act was a little bit different than some of the others, and what we think is going to happen going forward, not just in the state of Missouri, which is what we're talking about now, but all across the country. But before we get started, show your support for the Second Amendment by hitting the like button. And this is, I think this will be our final update to this saga. Is my guess.
I don't know, because I think Missouri, in which, God bless Missouri, they're, pretty stubborn folks. And so,
Oh, I was going to say, is that like a good? No, that's like a Southern. Bless your heart, Missouri.
bless your heart, Missouri.
Bless your heart, Missouri.
Well, no, but it's very good because they made the effort. They went to the extreme. And I appreciate that. I think it's really good.
As an extremist
As an
myself.
extremist myself, I'm glad they went to the extreme. They passed this law and they said, not only are we going to forbid our state law enforcement from helping the feds, we are putting it in writing that we believe all federal gun laws violate the Second Amendment rights of our citizens, and we don't want to enforce any of them.
Sure, they are all invalid as to the state of Missouri.
Missouri went all in.
Easier said than done.
Correct, because what we anticipated was that,
Well, the federal government would come in and say, no, 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 there's this little thing. There's this little thing called the Supremacy Clause.
yes, which they did, in which the Eighth Circuit Court of Appeals has now agreed that Missouri's law violates the Supremacy Clause. And so the next step will be the Supreme Court in the event Missouri chooses to appeal it, which they might do. But I think that where it has helped is that the states like Texas saw how far Missouri went, did not go as far as Missouri went. And I think there's actually language in this opinion that kind of supports that, because where this opinion really, really focuses on Missouri taking that extra step to go ahead and say these federal laws are invalid. They didn't just say they were unenforceable, they said they were invalid. As to Missouri citizens.
So what opinion are we talking about? We're going to flash it up here on the screen. It is the United States of America versus the state of Missouri, their governor, their attorney general, and we have a variety of amicus briefs that came in on this as well. This is number 23-1457, and this has been a saga, right? Because if you actually look back on this channel, Richard and I did a segment on this back in March of 23.
Sure. And what was your prediction then?
You know what? We're let's check out the prediction.
You got a crystal ball? What's going to happen?
Yes, crystal ball says the Eighth Circuit is going to agree with the district court, is going to say that this Second Amendment Protection Act is not constitutional. It violates federal supremacy, and the Supreme Court is not going to take it up because there is no fight to be had. So anytime a Second Amendment Sanctuary Act looks like this one, it is going to come down, and the Supreme Court is not going to tell us one way or the other. So just circuit by circuit, it'll fall. I mean, even the Fifth Circuit, who has done us so many wonderful favors. Now, Texas law doesn't go this far, and I don't think it's actionable, but I don't think the Fifth Circuit would do any favors had this occurred in the Fifth Circuit.
If you're going to, crystal ball that, I probably agree that that's probably a good assessment.
I love being right. I love being right.
Of course.
So I actually was a little bit out of time, right? Because I said Eighth Circuit affirms, Supreme Court won't take it up. And here we actually have Supreme Court didn't take it up. Eighth Circuit affirms. Now, of course, it will be appealed back up. But I still think the Supreme Court, I think they got too much to do to look at this. What do you? But
probably. Well, and that's the thing. The thing about it is
so smart.
The thing about it is that basically, the opinion seems to be mostly, first of all, does the United States have standing? And so I think that's that will be a fairly settled issue.
Yes.
Whenever you're saying the United States laws don't apply, the United States has standing
Yeah.
with regard to that.
Kind of poking that standing bear there.
Yes. And then they just simply said, look, we're going to go and declare the act invalid because you can't invalidate a whole swath of federal laws without implementing the Supremacy Clause. But what's very interesting is that it says in here that the parts of the law, it seems to give, at least give me the implication, that the parts of the law that are very similar to the Texas law that prohibit Missouri state officials from assisting in the enforcement of federal laws, that I don't think they invalidate that. I think that they say that they actually leave the implication that that perhaps may actually be valid.
Maybe, although I think that prohibition on like you can't help them out, and it was like if you help them out as a police officer in the state of Missouri, like you're going to get fired, and the agency, the city, the county is going to get fined. So I mean, it really had
It created a private cause of action.
It did create a private cause of action with attorney's fees and everything. But which generally, I love a private cause of action, and I love getting attorney's fees from the government, but. I mean, we have a scenario in which, yes, I think that you're correct. I think that we can still, under this opinion, say you're not allowed to help the federal government at all. But that's what gave the federal government standing, is that they were like, everyone's withdrawing from task forces. No one knows what they can tell the government. And so that harm is in part what made the lawsuit viable. So I don't know what that means.
So now that the federal government is emboldened with this decision from the Eighth Circuit, are they now going to file suits against states that have lesser egregious Second Amendment sanctuary laws, like the state of Texas?
That's my prediction, because they get standing. I think this says, no big deal. We cleared one hurdle, and so then after that, it's all right. How far does the state get to go? I mean, is the hypothetical threat of non-cooperation, not impeding, just non-cooperation, is that enough to invoke federal supremacy? And they're going to try. They're going to try.
But what's interesting about the Texas law is that the Texas law only applies to federal laws and regulations that were enacted after Joe Biden came into office. So it's very interesting that it specifically only applies to the enforcement of federal laws that came in after January 20th, 2021. And so really, I mean, the only kind of law that we're looking at with regard to that is that bipartisan, the Bipartisan Safer Communities Act.
Yeah.
So will the federal government have to point to an instance of them attempting to enforce that, not being assisted by local law enforcement, and then saying, aha, that is what's going to give us standing to sue the state of Texas?
I suppose that it would. So we'll wait.
We'll wait and see.
But lots of states, right? And I think probably if you live in a Second Amendment county or a Second Amendment city, I don't think the federal government, you're not first on the list. I don't think.
No. And also, the one thing that was very interesting about the Missouri law is it seemed to actually insist that not only was local law enforcement not to assist the federal government, but that they were actually supposed to come to the aid of citizens who were having the federal government acted upon them. And so it certainly seems that if the federal government, let's say that they were enacting a raid because they felt that there was an individual who couldn't possess firearms and somehow got one, they're trying to raid, that person could have picked up the phone and said, hey, local Missouri sheriff, get over here and basically fight with the federal government about protecting me.
Call Greg.
Yeah.
Or in this case, call Michael Parson.
Yes. So state of Texas law does not do that.
No.
So it doesn't put the local law enforcement in direct conflict with the feds.
Right. So, but, I do think, we know the federal government does not let things go.
No.
They've got to win. And I think they're going to wait, and they're going to tick off more states and not tick them off. I mean, maybe tick them off, like make them angry, but tick them off their list and say, all right, we're ready. Let's file a lawsuit. So I suppose my question to you, and I didn't pose this before, so I don't know if you have an answer, is what's a gun-loving state to do?
Well, I think that you can see where Missouri went. I suppose in good faith, you really can't go as far as Missouri did, but you kind of find some sort of middle ground, like the state of Texas did, and said, "Hey, this is our law. Come and take it."
Yeah.
Now, of course, one of the many anti-Second Amendment organizations to immediately jump on this Eighth Circuit opinion and issue a press release was Everytown.
Everytown.
Did you happen to read the Everytown press release?
I did.
And what did you think of
I
it?
did. I have never once thought of a Second Amendment sanctuary law as dangerous. But
Oh,
they
yes.
believe it to be highly dangerous.
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 In fact, I believe that's actually the title of their press release. Eighth upholds federal court decision striking down Missouri's dangerous Second Amendment Preservation Act.
If virtue signal, because that's what, and people have been mad at me before, but I think generally speaking, Second Amendment sanctuary acts are more virtue signaling than they are anything else. If virtue signaling is dangerous, buckle up, Everytown. I got you. You're putting out a lot of danger.
Oh, yeah. Well, and then they go on so far as to blame this particular law for a particular school shooting at the Central Visual and Performing Arts School in St. Louis. They directly blame that shooting on this law. Why do they do that?
Because the police would not come take guns out of the home when the shooter's family asked them to.
Yes, they say in their press release, prior to the shooting, the shooter's family asked law enforcement to remove firearms from the home that were ultimately used in the shooting because of SAPA. Law enforcement believed they were unable to remove the firearms. You know what? You know who was in the best position to remove the firearms from the home?
Who?
I don't know. Do you think our viewers know who was in the best position?
They might.
Maybe someone who lived there with an automobile who could have put the firearms in the trunk and driven them away.
Maybe the same person who called the police and asked them to do it could have just done it themselves.
Exactly.
No. You cannot. If the government will not do it for you, you are physically incapable of controlling your own life. And you know that. You know that. That's the way these things work.
It's a sad state of American
It's a
affairs.
sad state of American affairs. Do you invoke those beautiful papers you have in front of you
Don't
right
tread on me.
Don't tread on me.
Well, of course, this philosophically gets you to thinking about why is the federal government so big? Why does the federal government even have a police power? Because fundamentally, I don't think the federal government should have a police power.
No.
Our founding fathers are rolling over in their graves. They're literally rolling over right now because of the expansive federal government and the federal police power. I mean, when Thomas Jefferson wrote in the Declaration of Independence as a complaint against the crown that he hath erected a multitude of new offices and sent hither swarms of officers to harass our people and eat out their substance. I mean, does that sound like a man who believed there should be a federal police department?
You know that by heart.
Oh, it's my favorite line from the Declaration of Independence.
Wow.
Especially all of these, the ATF, the FBI, the DEA, the Department of Homeland Security, so many. And then, of course, we have our founding fathers, Madison and Hamilton. So do you think that the man who wrote Federalist number 45 would agree that there should be a federal police power? Even Hamilton, the ultimate believer in federal power, the man who wrote, "There's one transcendent advantage belonging to the province of the state governments, which alone suffices to place the matter in clear and satisfactory light. I mean the ordinary administration of criminal and civil justice." So
That's the job of the states.
exactly. Does that sound like a man who believed there should be a federal police power?
No.
So, the Supremacy Clause shouldn't even come into effect here because the court should have said, look, there's no authority for federal police power to begin with. So all these criminal laws, 18 USC, just throw it in the
Done.
garbage, the whole thing.
Done. Ooh. All right, well, we haven't had a good Edwin rant on this channel here in a while, so I hope you enjoyed that. If you did, consider subscribing, hitting the like button, and help us fight the anti-2A algorithm by sharing this video. And if you want more Edwin rants on this channel, leave us a comment. Until next time, we're the Arms Attorneys.